Can everyone hear? Crystal, can you hear?
Loud and clear.
Yes,
Okay.
thank you.
So it's February 5th, legal committee meeting. Just going to do roll call. Dominic is not going to be able to join us tonight. Here in the room, we have Jenny and Margaret. And online, we have Ronnie and Crystal. Linda Felhoff, I see that you're there. Other folks online are Vicky Daspludi and Tom, and I do not see any other council members online. So agenda tonight carried over 2 items from our last meeting. The accessory dwelling units and short-term rental. We don't have any documents relating to short-term rental right now, but I want to keep it on the agenda list so we don't lose sight of that. So what we're really going to focus on this evening is the ADU piece. And Crystal had sent out to us this morning a document where she had drafted some of the questions and issues relating to ADUs. So just to remind everybody where this came from is that, as you are aware, throughout Hudson, there are many, many buildings that have accessory dwelling units. Many of them are carriage houses. So that's a fairly common thing in the city of Hudson. And the idea was to take a look at what we would need to do with regard to zoning, code, etc., to allow people who do not currently have an ADU to construct one. So that's where this is coming from. We do have some zoning challenges in that our zoning code has a lot of setbacks that frankly many of the buildings that from the turn of the century even don't meet the current zoning code. So that's probably an issue that we need to take a look at. It also makes it difficult to do any infill housing at the moment. So that's kind of a separate issue. But Crystal, I think what I'd like to do is turn this over to you. And I think, Logan, if you can pull that document up, turn it over to you to walk us through what you have put together.
Sure. Sorry, it took me a minute to unmute. So what I've started to do is I took a look at Hudson's zoning code and what would need to at least preliminarily, or I should say initially, be amended to allow for ADUs. And I started putting together the preliminary parts of what would be a local law. So we've got, the initial definition, which, and if the committee doesn't, I would assume that everyone knows, but if the committee doesn't know, so essentially what we're talking about with these ADUs is we're not talking about just having a secondary rental apartment on a property, but what we're talking about is having a rental unit on the property, but also typically they're in situations where the property is owner occupied. So the property owner would either live in the ADU or in the principal dwelling, but typically they are present, and that avoids the issue of having, absentee landlords.
So,
Go ahead.
Chris, can I just ask you a question there? Because I saw this throughout what you put in there, an assumption that ADUs, there's kind of an assumption about how the ADU would be used. So I was hoping that we could really focus on what the requirements would be to actually have an accessory dwelling, and whether that would be for a family member to live there, or whether you were going to rent it, or whether you're going to have short-term rental. The actual usage should potentially be separate from a law that establishes the requirements for building an ADU.
So typically they are put all in one. So if you're going to add accessory dwelling units to the zoning code, you're going to talk about not just the building requirements such as setbacks and the zoning districts that it's allowed in, but you're also going to talk about the restrictions that are going to go along with that use. And that's where you get into whether you're going to have the ADU restricted to a family member or I shouldn't say a family member, a family versus not having any sort of restriction on who is actually going to be allowed to live in it. But typically, you would do it all in one. Because if you're going to pass a law just on the building requirements for an ADU and you're not going to get into the permitted uses or how it's going to be used, you're going to have a disconnect there when people are coming to apply for using and building one of these structures. So you need to give the building department and the planning board a full and comprehensive legislation on what the city council is intending and how they want these to be used.
So Crystal, the reason I'm asking that question is, if I look at a scenario where somebody is going to have a car, they're going to put in a carriage house or they're going to put an ADU on their property. Their neighbor already has an ADU, typically in Hudson would be a carriage house, that they are using as a short-term rental. So why, or maybe they're using it as a long-term rental, whatever, why would somebody putting up a new structure be subject to regulations that somebody with an existing structure is not subject to?
You wouldn't necessarily have to write it that way. So if you've got an existing structure that has an ADU in it, you could either grandfather it in, or you could legislate moving forward that, they're not going to be allowed for short-term rentals, or they are going to be allowed for short-term rentals. I mean, that's why some of this discussion is really needed in order to put together the full local law on it, because you want to address what's both in existence now and what you expect to be coming into existence in the future.
Okay. So if you want to just, I'll stop asking questions. If you just want to walk us through everything that you've put together here, and then once you're through, we can come back and ask questions.
So what I've done here is I've put together, or I've started to put together the outline for a local law for allowing accessory dwelling units in the city, because there is no express there's nothing in our zoning code that actually does expressly permit this. They've been coming in typically either through grandfathered uses or through the variance procedure, which is why you want to actually update the zoning law to be able to address that. What I did, just to give you some background as to where I got, the source for some of these provisions, is I took a look at the accessory dwelling unit laws that I found, that were adopted in the last 4 years by various municipalities throughout the state. And I went through them and I took a look to see what are the common features, as well as the guidance that's been put out there by various organizations about accessory dwelling units, because it has been a big push for this to change at the local zoning level throughout the country, particularly since COVID. And that's how I drafted these initial provisions. So, for example, the definition of an accessory dwelling unit being a subordinate dwelling unit located either within the principal residential dwelling, because you do see situations where essentially you put in an apartment in the basement, or perhaps an addition off of the main principal dwelling unit, or as a detached structure where you've got them either in, your carriage houses, above garages, things of that nature. Regardless, you want them to have their own separate ingress and egress, and that they are completely separate living quarters, which is why all of that is included into the definition. It's also why I noticed that our zoning code doesn't actually define a principal dwelling unit, which is something that we would have to include and add into our zoning code. That's why you've got the definition of a principal dwelling unit included with this. On zoning districts, what I did here is I made an assumption, and again, this is something that the committee would need to discuss, and it has to be in line with what the council as a whole would want to see with this. But I made an assumption that anywhere where there's essentially a single family dwelling unit that's permitted, that there would be accessory dwelling units that would be allowed as well. Then with that raises the question is how does the city and the building department and the council envision this being approved, going through an approval and permitting process? I would not expect, nor would I necessarily recommend, that all ADUs be administratively approved by the building department. I don't think that's a good idea. I think that there's definitely going to be some levels that need to go before the planning board to have a more comprehensive review of the site, to make sure you're not overloading a site, to make sure that you're not looking at this where if you already have a non-conforming lot, that you're not going to have issues with driveway access or whatever it might be. So that's where there's that consideration point under the zoning districts as to how the committee and the council would ultimately want to look at these. Would they want them to be conditional uses as a whole? Every single one be a conditional use? They're going to go to the planning board for a site plan review. Or are there some that would be, say you don't have a non-conforming lot, you have a carriage house that meets all of the setback requirements, there's no expansions that are necessary for any of the structures. If that's the case, do you want it to just be administratively approved through the building department? So that's one aspect that needs to be, considered and discussed at the committee level and at the council level. Then we get into the lot requirements, and that's where we talk about really the density issues and the setback issues that are already written into the zoning code. I did have conversations with the city's zoning ZBA attorney. She also provided me a history of the variances that were being granted by the ZBA, and what we were seeing pretty much across the board was that variances, in particular with setbacks, were being granted were being approved for these types of uses. So that says to me, if it's being approved over and over again, rather than legislating by variance, what really needs to happen is there needs to be an update to the zoning code to be able to allow for these and allow for them to be legal without having to go through the variance process. So that's where there's the consideration of the lot requirements. Any new ADU, any new structure that would be coming in should meet the setback requirements of the zoning code. But anything that's pre-existing, if it's essentially a grandfathered, non-conforming, pre-existing non-conforming use, then rather than having those property owners go to the ZBA to get variances, there should be a provision in the law that allows for the ADU to be situated or sited on in those structures, as a matter of course, even if it's not, even if it is a pre-existing non-conforming use, without having to go through the variance procedure. However, in those situations, I would strongly recommend that that those approvals go through the planning board for a full site plan review process. I'm just looking up here to see the next section. The other question that came to mind, and this may require some input from Craig as well, is if you have there's probably not going to be a lot of new buildings going up in the city of Hudson that are going to have ADUs in them. It's going to be really the pre-existing buildings that you're going to see this in, and the pre-existing structures. But if there is a new building that's coming in, where should that be situated with respect to the principal dwelling on the lot? Does the council not care? Can it be sited anywhere as long as it meets the setback requirements? Or do you want to see them more in the rear inside setback, with the principal dwelling units really being in the front, being in that front setback area? Most of the laws that I looked at for new structures, they did have the ADUs new structures being sited in rear and side setback areas, with one, with the main ingress and egress facing towards the street, and everything else would have to either face towards the side or the rear of the lot. I'm sorry, I'm just scrolling down on my computer because I can't see what's on the screen very well. Just too tiny. Under the restrictions, this is where we're getting into how are these ADUs going to be used. So I'm making an assumption that they are going to be accessory units to single family homes rather than two family or family dwellings. It doesn't make sense to have them on a multifamily dwelling. I don't think it makes a lot of sense to have them on a two family dwelling either. But again, that's for discussion for the committee and the council. As of right now, I've got the restrictions so that the ADUs are only considered accessory to a single family residential use. Similarly, they're not going to be accessory uses to commercial or industrial uses. That's pretty standard across the board for any sort of ADU law. Whether they're going to be allowed for short-term rentals or not, that is again discussion for the legal committee and the council. When you look at an accessory dwelling unit and you look at a lot of the legislation and the guidance that's been looked at nationally for them, they typically are either in response to, the housing crisis or to allow for essentially in-laws or family members to be able to reside in one lot. If that's the case, then you're really not looking at these for short-term rentals. You're looking at them for essentially long-term residential uses in the city. Maximum one per parcel. Again, this is something that is, standard across the board in every local law that I've seen. It makes a lot of sense because otherwise you're going to start getting into more of a multifamily situation. Driveway access, especially when you're looking at the density of the city of Hudson as opposed to a more rural community, I would anticipate that you don't want to have additional curb cuts. You don't want to have additional, requirements for driveways. For an ADU, you want to be able to have all of that shared with the principal dwelling unit, probably because there's not going to be a lot of room as well to be able to add additional curb cuts or driveway access. Common ownership. This is a big point with ADUs. It's essentially across the board. It's typically what you see is that you want the ADU has to have common ownership with the principal dwelling unit. So there's not going to be a situation where you're going to in the future allow for that ADU to be subdivided off into its own separate lot. Everything's going to be handled under one ownership. Again, that also gets into the point of absentee landlords, and you have more accountability for those accessory dwelling units when you have common ownership with the main principal dwelling unit. And then the last part, this is usually standard anyway for most zoning codes, where you're talking about it's not going to be allowed where there's a current building violation. Typically, you're not going to grant new approvals anyway if there is a current zoning violation on the parcel until that zoning violation is cured. This is just making it very clear that also applies here, and that unless the ADU is actually curing that violation, for example, perhaps you have one that's already in existence that's an illegal use, that unless that's the case, the ADU permit will not be approved. And then again, when we get down into the occupancy part, that's where you're talking about the use of the ADU, having the owner of the parcel actually maintaining a primary domicile, either in the ADU or in the principal dwelling. This is again a common theme that you're going to see in a lot of the ADU laws that you're going to look at across the state. There are some additional laws that will restrict it so that whoever is going to be residing in the ADU has to be a relative of the owner of the principal dwelling unit who resides in the principal dwelling unit. That is something that the city could do. However, the guidance on this, particularly if the part of the purpose is to address housing shortages, is that really is counterproductive to addressing housing shortages, because you're not opening it up. You're keeping it very restrictive as to who could actually rent and live in that ADU unit. And then going a step further, we're talking, when you're looking to other considerations, gross floor area. There are some laws that restrict gross floor area. There are other laws that leave it to just the state building code. in my mind, the state building code has habitable requirements to it with respect to the number of bedrooms, what the occupancy of the unit could be anyway. I don't know that it serves any purpose to go a step further. I could see restrictions being put on in more rural communities where you have the chance or the possibility of someone building an ADU that is almost the same size as the principal residence. And in those situations, you would probably want to restrict that so that they can't go as big. I don't know that that's really going to be an issue with the city of Hudson. There could be a situation, though, that you might want to restrict if the ADU is actually going to be in the principal dwelling unit, that you might want to restrict the expansion of that principal dwelling unit. So that's where that 25% to 40% perhaps of the principal dwelling unit comes into play, where you say, okay, it's not going to be, you're not essentially doubling the size. Again, may not be an issue with the city because you're going to have restricted building space anyway. And then that's primarily it for summarizing it. I do think some of these provisions, before finalizing, there should be just a sit down or at least eyes on it by Craig as well to make sure nothing is jumping out to him to say, oh, wait a second, this is going to be a problem with our current zoning code, or you know what, this isn't really going to be an issue for the types of lots that we're going to be dealing with here. But otherwise, that's a summary.
Ronnie, do you have any thoughts?
It's a lot of information to digest. I don't actually have any thoughts right now, but I think Crystal has given us a good amount to think about for the law.
I do.
Yeah, Jimmy.
I can think of there's a couple of points here. I can think of a couple of scenarios, especially in the fourth ward, where there are some very, very small homes that are set far back from the road, far enough back from the road that you could actually fit another building in front of it. So I think the restricting this to building in back of or to the side of a house wouldn't work in those scenarios. I can think of 3 right now in my head. As far as restricting this to relatives living in them, I think that is, especially in the current state of things where we're in a high housing crisis, I don't think that that's okay. I think it should be open to whoever would want to rent. And I think that people should also be able to rent these as short term. That people are already renting them as short term in some cases.
I agree with that. Yeah, my concern, I agree pretty much with everything you're saying, Jenny. My concern is that if we already have folks with carriage houses that they're using as short-term rentals, I do not see why a new structure or an existing structure that's rehabbed should be subject to rules that are different from existing structures. The other thing, Crystal, I'm thinking is with regard to the setbacks and the waivers that the zoning board is giving. As you know, there are many buildings, many homes in Hudson right now. I can just walking down Union Street, I can point out the majority of them actually do not actually meet the setback requirements in our current zoning. And I think perhaps we should begin by re-looking at that zoning and make it more reasonable so that we don't have to do all of these waivers. And that would also address some of the infill housing issues, but perhaps we begin by attacking some of those zoning issues so that we don't have to have the setback discussion. Other than the situation where you have, I'd like to hear more about the non-conforming use situation, but I think having any of this, there may be unique situations that may need to go before the planning board, but as it is, the planning board has an incredible backlog. And if we're talking about something that can be handled by buildings, that doesn't have any major issues with regard to zoning. I think having it go through planning board would basically mean that none of this would happen. So those are some of the concerns that I have looking at this. So, Crystal, when you were talking about things that would need to go to the planning board, you did not think that they should all be handled by the buildings department? Because you said there were situations where, if you have a conditional use or you have a non-conforming use, can you talk a little more explicitly about what kind of scenario do you think should be going to the planning board?
My initial thought for what should go to the planning board is if you have one, a non-conforming lot, or the existing structures do not currently meet, the setback requirements. And that's just to make sure that you don't end up having a lot that ends up being, you end up putting too much on. It ends up being essentially overly dense. So that was, those
sorry,
were, it was,
Can you just explain, like in layman's language, what you mean by a non-conforming
yeah.
lot?
So a non-conforming lot is when you were talking about setbacks, you're talking about, okay, the structures have to be so much, so many feet from usually the center of the road. A non-conforming lot is where there is a lot size requirement in a zoning code, and that lot does not meet that size requirement. So, and that would be considered, it's legal, it's pre-existing, it pre-existed the zoning law. So it's a pre-existing non-conforming lot. So it's the size of the lot itself. And that's where there will typically be some form of minimum lot size that's required so that you're not putting a ton of structures on something that's just really not large enough to handle it, or uses that are not large enough to handle it. And when you had mentioned going back and kind of taking a look at the setbacks for the zoning, the only thing I would caution on that, at least to do that before moving forward with an ADU law, is that really two things. One, my understanding is that there are potential grants that could be available, funding sources that could be available to the city if there is a law for accessory dwelling units specifically in place. And if you're going to go through and you're going to review the setback requirements for the various zoning districts that allow for residential uses, that is going to be quite the undertaking. Okay. It's not just a matter of sitting down with Craig and kind of taking a look at what the variances that have been granted. You're going to have to go through and do a essentially a comprehensive review to see what are you affecting by changing these setbacks. And it should, and I would expect it will, take a little bit of time to be able to do that review and update the zoning code accordingly. It is not uncommon at all for there to be non-conforming structures in any municipality. It happens as a matter of course because zoning laws come into effect at various times throughout that municipality's history. And when that happens, that's why you have the ability, and that's why there are provisions for non-conforming structures, is so that it doesn't make them automatically illegal. There's a process. They can go to the ZBA to be able to get an area variance. It's why area variances are a lot easier to get than a use variance would be. And what I was proposing with the ADUs, at least, is to cut out that variance process. So we can streamline at least the ADUs a lot easier without having to go through and essentially redo the setbacks for what could be essentially the entire city. I mean, that really will be a bit of a process.
And so how would you bypass the area variances? Explain to me how that would work.
We would permit, because the local law would permit the ADUs to be allowed in non-conforming structures.
But would you then require that if they're in a non-conforming you know, it's non-conforming lot that they have to go before the planning board?
That's just my recommendation. You don't have to do that. You can go and have it be administratively approved. Um, and that's something, and it's, you know, it's just something to discuss. My only thought with having a planning board taking a look at it is because you already have non-conforming structures. You know, someone at some point took a look at the city and said, hey, these are the setbacks that we really want to see for a variety of reasons, for health and safety and planning reasons. So if you're going to allow for then rentals essentially to be allowed in those structures, you'll want to take a look at them and just make sure that, you know, there's not going to be an issue of having, again, you know, density issues or problems, you know, density issues on the lot. That was my suggestion. It doesn't have to be done that way. You can go ahead and have it administratively approved to the building department. Either way will work, but my only caution is I do caution if there is any sort of timeline that needs to be put in place for this law to be adopted sooner rather than later, I caution against revising all setbacks first.
Okay. Do you have any questions? Anyone else want to bring up?
No.
Yeah, so we just got this today, so I think we need a little time to think through. And in your email, I think you recommended that we maybe talk to Craig and get some input on that. Anything else, Crystal, that you want to bring up to us right now?
Can I talk, Margaret, for a second? It's Vicky.
Oh, sorry, yes, I didn't see any hands raised. Go ahead.
I didn't, yeah. Crystal, I think you did a good job. Very important to keep in mind that these ADUs have to be in the rear or side, mainly, I would think of the rear, because we have a historic city. Aesthetically, they have to be pleasing, and we can't afford to have, you know, people start erecting, you know, ugly things around the city, you know. So that is, I think, an important point. But let me ask you, will there be restrictions that they have to be two separate entrances? How is that going to work? Like, can you have one entrance and still consider it ADU?
So typically when you have an ADU, I mean, you're gonna want to have a separate way for whoever that renter is or that whoever's occupying it to be able to access it without having to necessarily go through the principal dwelling. Usually that's what's desired even by the individuals that occupy these. What you're looking at is trying to make sure that you've got two completely separate dwelling units. So I suppose if you were going to allow for one entrance way, there would still need to be, as you're walking into that building, house or whatever structure or whatever it is, there's still going to be a separation that's going to allow you to go into the principal dwelling unit versus the ADU. And what's important about this is to be that separate dwelling unit, to get that separate CO, they're going to need to have, you know, their own kitchen and their own bathroom facilities, and all of that's going to be separate. So that's why you are typically looking at them as having, you know, two distinct entrances.
But they can be attached to the principal house.
It can, yeah, absolutely. You
Okay.
see it all the time with like basement apartments where there'll be a separate entrance for either a basement apartment or a addition that was built onto a primary residence. And there'll be two separate entrances, one for the main primary residence and one for whatever that addition or, you know, in-law apartment. You see them with in-law apartments as well.
Yeah, thank you.
Anything else, Vicky?
No, that's good. Thank you so much.
Logan, are there any hands raised?
No.
Okay. So I think we will take this back and maybe follow through with Craig and return oh, hang on. Sorry, excuse me. And then we can return to this. As I had indicated at the beginning, I put STRs on just so that we wouldn't lose track of that. I think we can have that as a topic with some documentation, like we had already in one of our last meetings. We looked at the current code, we looked at current penalties and so forth. And I had met with Michelle on some of this. At the moment, I think the last count we had was 69 STRs. I think that's something
67
that,
now.
sorry?
67 now.
Okay. That is something that I think we need to take a look at. And other than that, is there any, under new business, Crystal, I do know that Dominic had asked me to bring up to you whatever changes we need to make to the code with regard to the executive director of HCDPA being the person signing off on the floodplain engineering reports. You remember that whole issue that came up?
Oh, yes, I apologize. That one fell off the radar.
This is something that came up with Colarusso. For some reason, it was written in that HCDPA executive director, which is a position that doesn't actually exist, has to sign off on the engineering report relating to floodplains. And so Dominic has been acting as executive director so that we could get through the Colarusso project. That project, all of the work has been done. The final report from the engineer, I believe, has not yet come through, but Dominic would really like to see us looking at revising the code so that that gets, and I believe what we decided when we discussed this when it came up was that the appropriate place for that would be in code enforcement. And so we could have that addressed in the code so that we can draw a line under that in case any other projects come up so that it doesn't have to go through HCDPA.
Okay.
Okay. And then the other issue that Dominic had brought up as potential, can we discuss tonight, was the issues regarding the harassment law. My understanding of that right now is that we discussed it, it went to the full council, and now it sits with the full council. And I don't think there's any further discussion necessary from this committee. Yeah, I think at this point it's gone to the full council, and that's where it needs to be resolved. Okay. So if we don't have any other new business, do I have a motion to adjourn? Motion from Jenny. Do I have a second from Ronnie?
Second.
Great. All right. Thank you all very, very much. Have a lovely evening.
Good, thank you.